Good evening, everyone. I'm Andrew Schaefer from Trafalgar, based in Trafalgar's Johannesburg branch, and it's 5 o'clock. We'll make a start with our webinar titled Governance Best Practices. This is our 7th webinar of our 2023 series, and joining me tonight on our panel is my colleague Karine Kutsia, based in our Cape Town office. Karine is Trafalgar's property management consultant with over 20 years experience. We also have Peter Menon joining us from Cape Town as well. Peter is head of legal and head of marketing for Trafalgar, and together we'll be covering the topics that you see on the agenda in front of you. Just a reminder that the webinar is being recorded, and we will upload the recording on our training website. The details will be given at the end. All of our contact details will also be provided at the end of the presentation. You're very welcome to make contact with us with any questions which follow. We will gladly help as best we can. We will try and answer questions as they arise through the webinar, so please feel free to log any on the Q&A, and Karine and I will try and respond to those. Any we don't get to tonight, just because of volume, we can certainly come back to you, or you can contact afterwards, and we'll certainly try and cover any regular topics during the course of the presentation as well. So a reminder that our training website, training.trafalgar.co.za, does have recordings of all of our prior webinars. It's also got lots of useful training. It's all completely free. It all relates to community schemes and managing community schemes. And Karine is available as a facilitator and moderator to provide any input or guidance or questions which might arise. We'll end promptly at 6. And if you would like a copy of these slides or a copy of the recording and the Q&A, please just pop your email address into the Q&A. We'll pick that up afterwards, and Karine will make sure that you get copies of the Q&A and slides, whatever you ask for, tomorrow by email. And as I said, the recording should be uploaded by Monday, and the address will be given at the end of these slides. All right, so let's make a start. It's an important topic because governance best practice is an important expectation of trustees and directors of community schemes. Now, I know it can be quite a dry topic. It can be quite a heavy topic because legal compliance and governance, can be quite overwhelming if this is not something that you do every day. And also, I'm very aware that most trustees and directors fulfill these roles for free after hours in their spare time, and are doing the best they can, and often don't have a lot of background in this particular area. That's the role of the managing agent, and there are many other support services available to help, to provide guidance, to do the work where possible. But ultimately, and at the end of the day, the trustees and directors have the fiduciary responsibility and legal responsibility, and they do need to authorize the steps to be taken to make sure that legal compliance is met. We're not going to go into every last point in great detail. It would take too long. It would probably be a bit overwhelming and intense. So really the idea tonight is just to give a flavor and an overview of what we consider to be important governance areas for community schemes, and particularly directed at trustees and directors who are accountable, and to indicate how those governance steps are to be achieved, what they are. We've also talked about what is actually legally compliant, and then what is a recommended best practice. Best practices aren't actually legal requirements, but they certainly do go a long way to ensure that there's effective management and effective performance, both of the board of directors and trustees, as well as the community scheme as well. So that's where we're coming from this evening, is just to cover that spectrum. And it's easier than it seems, because often once the first step is taken and a registration is in place, then it's in place. Then there's typically a registration number or certificate, and then it's a question of just annual renewals, which we'll touch on, and it can tick over. So what we're going to do as well is make a governance checklist available, which we can circulate to anyone that asks for copies of the slides or the Q&A. And that governance checklist is a nice prompt. It's a nice reminder of, what to look for, to double check that there are no gaps, and to use, as a cross check, or almost like an audit template, to make sure that you can check on the governance status for your community scheme. I'm not going to belabor the point about penalties and sanctions. They are referred to in the legalities. Let's rather be positive and talk about what can be achieved, how it can be achieved, and actually it is very achievable if there's a list and clarity on what those items are. All right, so moving along to the next slide, which Karine will bring up for us right now. These are some of the important ones just to touch on. So maybe the first point is CSOS, which is the Community Scheme Ombud Service. Many of you will know of it. It is the statutory body which was created for community schemes, and all community schemes of whatever type, whether they're sectional title, homeowners associations, retirement complexes, share blocks, they are all required to register with CSOS, and the registration will achieve a registration number. That number format has recently changed, and a registration certificate. And that is a mandatory requirement. And until recently, we were advised by the CSOS Chief Ombud that only about 50% of community schemes in South Africa are currently registered. So actually only half are compliant, and that sort of is a big gap that needs to be closed. Once the scheme is registered and has a registration number, then annual returns are required. An annual return is a particular form, and the form needs to be returned together with the AGM minutes and the budgets. I think Karine can comment on that really, so they can check what levies to expect. And there are quarterly CSOS levies that are required to be paid, linked to the registration. And that's really the mechanism by which CSOS is funded. And many of you will know that the benefit of that registration, apart from legal compliance, it does provide a dispute resolution service, which is a very effective and low-cost way to refer disputes to be adjudicated independently with a binding ruling opportunity that arises from that. So enough about CSOS, but just to say it's a reasonably easy step to take, and certainly any managing agent can assist. And once the registration takes place, just bear in mind that there are quarterly payments that need to be made. That needs to be submitted with a particular reference number linked to the registration number, and those annual returns to make sure that that registration and legal compliance element stays up to date. Then with SARS, which is all about tax, so all community schemes need to be registered with SARS for tax. That registration will achieve a tax registration number, which does need to be on record. So that's the first point. SARS also requires a public officer to be on record for that particular entity or scheme. And the public officer is really the person that will be responsible for filing tax returns, for addressing tax queries, and for taking accountability for the tax matters for that particular community scheme. So we see quite frequently with new buildings coming on that the buildings aren't registered for tax. They do not have a tax number. They do not have a registered public officer, and that would be a compliance gap and a legal sort of issue that would need to be addressed. So important to realize that there is that registration requirement with SARS for community schemes. Then quite recently, there's a requirement to register community schemes with the information regulator and to register an information officer for the particular community scheme. The information officer is accountable for the protection of personal information in a community scheme, which would be all things related to personal information, both of owners as well as residents, as well as visitors. I won't go into too much detail there. We could possibly go into more detail on a following webinar, but there does need to be an information officer that is registered, and a registration certificate is provided for that. Just to mention that that could be a chairman, it could be a trustee or director, it could even be an officer of the managing agent, somebody senior, somebody that has influence in the community scheme, who could be accountable for personal information protection and the privacy policy, and making sure that any breaches are properly investigated and reported. So another statutory requirement there. And then in terms of payroll, there are the items you see there, which are important to bear in mind. So this is for community schemes that have employees on their payroll, where the employees are cleaners or maintenance staff or access controllers, whatever the case might be, where there's a payroll. The the scheme would need to be registered for UIF, for workmen's compensation, and then also for skills development levies where the payroll exceeds 500,000 Rand per year, or they're more than 50 employees. So those would be the important registrations, which would be both with SARS as well as the Department of Labour. So a quick checklist there. Hopefully all of this is familiar to you and you've got this covered. If not, these appear on the governance checklist, and that would be able to spot and record the registration number to make sure that you've got an easy record of what the statutory registrations are. Could we move forward, please, Karine? Going on to financial management, which is a key area, because effective financial management is obviously critical. Buyers and sellers require the audited financials. The audited financials are obviously submitted to SARS every year, and they're also used for CSOS annual returns. So basically at the AGM, the audited financials need to be presented and reviewed, not approved, because they're approved by signature of 2 trustees and directors. But that is a legal requirement that the audited financials are signed off. And very often the signing off of those audited financials is a dependency to be able to be ready for an AGM and to convene an AGM. And we often run into queries where new trustees or directors are not comfortable to sign audited financials for prior periods where they were not in office, where they weren't involved, and therefore where they don't feel they're aware of the financial statements. That is a problem which needs to be addressed either by a thorough review of the management accounts or discussion with the auditors, but it's certainly a pity if sign-off of the audited financials, assuming queries are resolved, delays the AGM. Then, as I've said, the audited financials need to be submitted to SARS with tax returns and to CSOS with the annual return, and the auditor does require a letter of appointment on file to go ahead with the audit, and therefore that in turn is a requirement or legal requirement to go ahead with the audit. So I think these are just sort of fairly simple items related to the audits, which are particular legal requirements that are worth being aware of. And, you know, all of this becomes relevant after the financial year as the audit file is prepared, as the audit timetable needs to be finalized, and to make sure that, you know, everyone is working on track and on time for the AGM to be convened on time, which would be within 4 months of the financial year end, or typically 6 months for a homeowners association. So moving away from squarely legal requirements to good practices or best practices, you know, this timeline is all about being prepared and aiming for a punctual AGM. So the legislation, the sectional title legislation, as I said, does specify that an AGM must be held within 4 months after the financial year end, and for a homeowners, 6 months. That means that there's a timeline to have the audited financials signed off from the beginning of the new financial year. And what you see in front of you is the typical timeline that we apply to be ready and on time for an AGM to be convened within those timeframes. So it does need to be actively managed, otherwise it actually becomes difficult to have the AGM on time. And the AGM is a really important milestone to approve budgets, approve maintenance plans, insurance, levy schedules, elect new trustees and directors, etc. And it's really important that it's held on time because it keeps the governance cycle of community schemes up to speed and on track. So important points here about, you know, preparing the audit file, handing the file to the auditors, you know, having an audit program that links to each of these steps. And this goes a very long way to make sure that everyone is organized and prepared and ready for the AGM to be punctual and on time. Apologies, I lost connection. So the sectional title trustees can increase levies by up to 10% from the beginning of a new financial year. That actually means that the budget needs to be prepared in advance of the financial year to decide whether the levies need to be increased from the onset of the new financial year. Now, it makes a lot of sense for that to be checked in terms of whether a levy increase is required. And for this reason, we recommend that a budget is started in the 10th month of a financial year, which would have 9 months of history to work on. Typically, a building inspection, a maintenance inspection makes a lot of sense, updating the maintenance plan. All of those are important inputs and assumptions into the budgeting process. Therefore, if the budget is properly developed, reviewed, agreed by the trustees or directors by the beginning of a new financial year, the trustees are then very well equipped to decide whether a levy increase punctually from the beginning of the year is necessary, or whether it can be decided at the AGM. But remember that the AGM is typically 3 or 4 months into the new financial year, meaning that the first quarter, the levies will not be revised to match potential increases in expenses. And, an example is that, a 6 or 7% levy increase from the beginning of a financial year, which in the case of sectional title buildings, trustees are able to decide, would possibly have to be a 10 or a 12% increase at the AGM because you've lost a full quarter of a levy increase impact. So I hope that makes sense, and that's really why it's very useful to budget in advance of a new financial year, have the building inspection inputs, the maintenance plan inputs, any other inputs in terms of projects required at the community scheme, and then to decide for sectional title buildings, do we need to go ahead with a trustee-derived increase of up to 10%, which is specifically allowed for, and in the case of homeowners associations, a final draft or director-approved budget by the beginning of the financial year is very helpful to be ready for an AGM on time, and it also allows it to be quite quickly and easily updated in the month before the AGM as the agenda packs are being compiled, because you've got a very good working draft, and the last few months of history can be added to update the budget accordingly. And then we'll come to more on this point too, but there is a requirement for, in sectional title schemes, all owners to be advised within 14 days after the levy increase is effective of what that levy increase is going to be. So that is an absolute requirement, and we have seen several cases where legal levy collections are lost because that particular circular was not circulated, the owners were not correctly advised in terms of this legal provision, and that did compromise the whole legal levy collections claim. So an important point, it might sound like it's a sort of standard communication, but actually it's an important legal requirement to be able to enforce legal levy collections. Next, please, Karine. All right, I'll just gloss over this quickly, but this is the recommended timeline for budgeting to start in the 10th month of the financial year, and to review it in the 11th month, finalize in the 12th month of the financial year, and to make that decision in the case of sectional title schemes whether to implement a levy increase. And remember that the levy statements go out in advance of the month end, in advance of billing on the 1st, and therefore the final decision would need to be taken actually before the year end is finalized. And then the budget is presented at the AGM, and it can be approved with or without amendment. So that's a recommended timeline, a good practice, not necessarily a legal practice or not necessarily standard in every single case. Thank you, Karine. Right, over to you, Karine, with annual general meetings.
Thanks, Andrew. So talking about annual general meetings, Andrew already alluded to the fact that a sectional title scheme must have the AGM within 4 months of the financial year end. There is certain items that can happen, or consequences, if you want to call it, if you don't have your AGM in time, if you don't have your AGM regularly. We've seen schemes where there's many years that they haven't had an AGM, and some of the consequences that I can can I just mention is a possible shortage of funds. If the levies aren't increased regularly, the body corporate will not be able to meet their expenses. The maintenance plan, we'll get to maintenance shortly, but maintenance plans need to be discussed and updated at the AGM. So if you don't have your AGM timeously, that will be missed out. The owners don't get an opportunity to discuss their concerns. So that is also something that they are losing out on. For an HOA, because we're talking about community schemes as a whole, for an HOA, this timing will be stipulated in the memorandum of incorporation if it's a company, or the constitution if it's a common law association. Sectional titles schemes have a prescribed agenda that must be followed. The items can be added to the agenda, but the prescribed agenda items cannot be left out. You have to follow those. And just in terms of some best practices, as Andrew said, there's to have a clear timetable, to plan ahead, to not just run around close to the AGM. Now we've got the financials, now we're running around, but to plan ahead, to have a timetable, to do the inspections, to update the maintenance plan timeously, do the budget timeously, get the signed audited financials, get a trustee report ready, because that is also a legislative requirement, is that a trustee's report must be attached to the notices that goes out. Trustees cannot just give a verbal report at the meeting. It must be a written report sent out with the notices. And you also need to adhere to the stipulation of the notice period. So for a normal AGM, that's a 14-day notice period. If there is special resolutions or unanimous resolutions on the agenda, then there will be a 30-day notice period. And there's also exceptions to the rule where the trustees deem a matter to be urgent. They need to have an urgent meeting. The trustees can actually then give 7 days notice, but generally 14 days notice for an AGM. Then we can look at insurance. So it is a legal requirement of the Sectional Title Schemes Management Act that all bodies corporate need to have a valuation done every 3 years. As a good practice, we also follow this with our HOAs, even though it's not a legal requirement for HOAs. It is a best practice to make sure that your insurance cover is adequate, that it is relevant, that it is up to date, that you don't get into a situation where there's a claim and the insurer assessor comes out and deem you to be underinsured, and overinsurance can also affect your insurance premium. So it is good to have this valuation done for all schemes regularly to make sure that your insurance is in line with current replacement values. It is also important that you should have adequate fidelity insurance cover for your scheme. And the insurance replacement value schedule needs to be confirmed annually at the AGM. As I said, it's part of the legal prescribed agenda items for an AGM. So just some best practices that we can highlight is that also for an HOA, it's important that you insure your common property fixtures and improvements. It's generally done by a sectional title policy, but for an HOA, we need to make sure that it's specifically covered. And it is important to have a good relationship with your insurance broker, and refer questions to your broker. Speak to them, get to know them. We have an in-house brokerage, Trafalgar Financial Services, that you can have a good relationship with. And it's important to also, when your insurance is renewed normally every year, to get quotes, get 3 quotes, have a look what is out there, compare the pricing, and see what will be best for your scheme in terms of the insurance. Then going on to maintenance, some legal requirements. We have obviously the 10-year maintenance plan. That is a requirement for all sectional title schemes. The reasoning behind the 10-year maintenance plan is preventative maintenance. I think for too long, we've seen schemes that are just reactive and just act on something that happened. That is why this whole 10-year maintenance plan idea was introduced, to be able to plan ahead, plan for 10 years ahead, and to do proactive maintenance and not just be reactive. Also, we've got some compliance items, like, for instance, your electric fence compliance, your lift compliance, fire equipment that needs to be serviced every year with a major service every 5 years. If you have gas installations, you need compliance certificates for that. And then just some best practices ideas with regards to waterproofing. Have it serviced annually. Have a look at your waterproofing. Be, as I said, be proactive and not just reactive. Clear the gutters monthly, especially in the rainy season that we're currently having in Cape Town, for instance. Look at regular rust proofing, painting of metal windows, frames, doors, and other fittings. If you have a generator, service it regularly. If you have solar installations, make sure that they are also current and serviced and maintained. The bottom line, I think, is just to be proactive and not just be reactive in terms of that. Then the next topic that I'm covering is enforcing the conduct rules. So the requirement for all community schemes, be it sectional title or HOA, is that as part of the registration of the scheme with CSOS, you need to give CSOS a copy of the rules of the scheme, the conduct rules, management rules, if it's a sectional title scheme, building guidelines, architectural guidelines, whatever rules the HOA may have must also be filed at CSOS. And then in terms of sectional title schemes, it is also a requirement that CSOS must approve the rules. So for an HOA, that is not currently a legislative requirement, but CSOS welcomes it if you give them your HOA rules to have a look at and to approve in that sense. In terms of the sectional title schemes, must be approved by the owners first, conduct rules by special resolution, management rules by unanimous resolution, and then approved by CSOS. Unfortunately, the legislation states that rules are not enforceable if not approved by CSOS. So even though the owners may have approved it at an AGM, it's not enforceable before it has been approved by CSOS as well. We have found in recent times that the workaround by CSOS has definitely improved. They are definitely quicker in terms of approving rules, and we also have escalation channels available at CSOS for our schemes where we can assist with getting approvals quicker. And then, just some best practices is to modernize your rules, have current rules. I've seen schemes with rules from the 1970s. Some of those aren't relevant anymore. So it is a good practice to update your rules regularly, make them relevant, make them modernize them in terms of what is in terms of your scheme. Don't just copy and paste another complex's rules, because they all have different requirements, all have different things. And then in terms of rule breaches, it is good to have a portfolio of evidence. Have photos, if you have security guards, they can have OB book entries. If you have CCTV recordings that you can use, witnesses, so that it's just not just a he said, she said type scenario, but to have that. In terms of rule breaches, it is a good practice to issue a written warning first before taking further action. In terms of fines and penalties, remember that you cannot issue fines or penalties unless it is provided for in the rules. Another point in terms of common law of fines is that you have to hear both sides. You have to give the party the opportunity to state their case before you fine them. And once you do fine them, the fine has to be reasonable. It can't just be 6-month levies because your cat came out of your unit and walked around on common property. It has to be a reasonable fine, and also have an appeal system. Have this whole process clearly defined in your rules to make it enforceable, to make it sure to ensure that you can take it forward and that you're legally compliant. And then at the end, if internal remedies are not working, if internal discussions with the owner with regards to breaches are not working, there is always the option to escalate to CSOS and to get a CSOS ruling and get an adjudication order. CSOS is free of charge, definitely quicker and easier than going to court, but doesn't rule out the legal system. The legal system is still available. You can still go to an attorney, get legal advice, go to court if that is what is needed. I think that is my story. Thanks, Andrew.
Thank you, Corinne. Kiddo, over to you. Thank you.
Thank you very much, Andrew. Thank you, Corinne. Evening, everybody. The two topics that I'm going to cover this evening is human resources and POPI, some very legislatively heavy subjects, specifically when you're dealing with human resources, because there's this interplay between all of the different pieces of legislation. When you're dealing with the Basic Conditions of Employment Act, you're dealing with the Sectional Title Schemes Management Act, you're dealing with the Labor Relations Act, and obviously tax legislation as well. So just having a look at human resources, I think one of the starting points when discussing the subject matter is that sometimes an expert is better at assistance when it comes to HR. The process is so incredibly important when you're following HR processes. Some of you might have previously been to a CCMA hearing or even the labor courts. In terms of those, you're having a look at things like procedural as well as substantive fairness. Procedural fairness in that your procedure needs to be 100% correct for any disciplinary inquiry or action, and substantive fairness meaning that the actual claim made against the employee is of substance, that it warranted what was given at the disciplinary inquiry itself. So you're dealing with these multiple and complex interplays between legislation. There are definitely some legal requirements when it comes to community schemes and what we are required to do. Things like a signed employment contract for staff employed by the property in terms of the Sectional Title Schemes Management Act regulations. Your contracts are vitally important when it comes to this, and updating your contracts and having a look at the contracts that have been used by the body corporate or HOA. Recently, there has been some changes to the labor legislation, specifically when it comes to parental leave. Just updates on that is that in terms of parental leave, whoever that person might be has an opportunity to take 10 days leave. That needs to be stipulated in your contracts, and that's why I'm saying the contracts need to be updated, as well as adoption leave and commissioning parental leave is also now being brought together in terms of the Labor Relations Amendment Act. So it's all of these interplays, all of this complex legislation that needs to be brought together when it comes to your employment contracts. Staff employment files must also include an ID copy. Here I'll take a stopping point and ask you the question of what reference checks are you busy utilizing when you are employing staff at the sectional title complex or HOA. It's very important not just to keep the ID copies on file, but also obviously having a look at things like credit checks, criminal checks. There are multiple service providers that you can utilize to take you through these processes. Yes, they do take some time. Usually in terms of a criminal check, it's going to take you between 2 to 6 weeks. However, if you're dealing with people that are working for the community scheme, I think it's vital that you have a look at past history, having a look specifically if a person is dealing with cash or finances, which is a requirement to actually do a credit check, and have a look at what that person's personal finances actually look like when it comes to handling cash and finances. Foreign nationals must have a valid visa, South African ID or refugee status document. As you may well know, that time period has now been pressed forward to the 31st of December for pending visas and waiver applications. So there is still some time to get those visa applications in and processed before that time period. But in terms of the legal requirement, that must all be kept on file, and you must make sure in terms of the Immigration Act that all parties working for you are legally in the country. When it comes to UIF, workmen's compensation, and skills development levies, these are all very important when it comes to your own compliance within your regulatory and compliance aspects. Now, in terms of our procedure, when you're dealing with Trafalgar, we'll obviously submit your EMP 201s, your SARS declarations, Your UIF, STL, and PAYE will be submitted at the same time. When we go into your provident fund, as well as funeral plans, we regulate payroll, and we work through workers' compensation and make sure that you're correctly registered in terms of your workers' compensation as well. But with employment, like I said, there's all of these complex pieces of legislation having an interplay. There's great articles on the web that you can go and have a look at when it comes to Basic Conditions of Employment Act, but your contract is basically the thing that you look for, that you've got updated contracts that speak to things like performance, KPIs, working standards, etc. Recommended best practices, working schedules with clearly defined reporting lines is vital. KPI indicators, and perhaps taking people through performance review processes and utilizing correct templates and documentation will always be incredibly important to make sure that the slips, efficient leave reporting to payroll administrators to actually track leave, also vitally important. At the end of the day, these always crop up and they always create a bit of a problem if these haven't been allocated correctly or haven't been reported correctly. And compliant performance management processes, like I've spoken about previously. You can't hold a person to a certain standard if they don't necessarily have a correct role profile, if they've got certain KPIs that they need to reach. And performance management, as much as it's a process, it's a consultation process that does work in the favor of the community scheme if managed properly. But like I said at the beginning, the most problems that occur is actually through process. Make sure that the processes are correct, make sure that the documentation is correct, and hopefully through that, you will reach a certain level of standard that you don't necessarily need to run to the CCMA and the labor courts should issues arise. Corinne, you can go to the next slide for me, please. Thank you very much. My favorite topic, as Andrew will know, POPI and compliance in terms of POPI, or PAIA, as some people call it. So when it comes to POPI and PAIA, I just want to deal with a short introduction. As Andrew said, there's multiple definitions when it comes to personal information and processing. We're talking about responsible parties. The responsible party would be the community scheme. We're talking about the data subject, which is the members within the scheme, any employees within that scheme, the scheme itself in certain instances when it comes to their own information. The operator, which would in most cases be Trafalgar or a similar party who's processing the data, could even be contractors, persons looking after the security of the complex itself, and then your information officer, which is usually the head of the organization as is stipulated in the legislation. It could be Trafalgar, you could appoint us, or a trustee or a director who is going to handle the information that is regulated within inside the scheme. It's vitally important when you're dealing with POPI also to understand that personal information is a very wide-ranging subject matter. It's not just ID numbers, it's not just contact details. It includes address information, it includes financial statuses, it includes things like biometric information about race, and all of these are encapsulated within the definition of personal information. Also, when we're utilizing the term processing, it's also not just about capturing the information and keeping the information, but it's also about disseminating of the information. So giving the information out, as well as how that information is processed through your different contractors. So in terms of the legal requirements, the information officer for the scheme must be registered with the information regulator. This is done online through their platform. It's pretty simple to go and do. The certificate is provided thereafter. A personal information risk assessment must also be done. This is a short little test inherently of the scheme's residual and inherent risk. So the risk associated with the actual data subject's data versus the best practices that you've implemented to make sure that the processing is done correctly at the scheme. Your POPI policy must be developed and approved within the scheme. This is done by ordinary resolution. This term is used so loosely: a POPI policy, a POPI manual, privacy information agreement. I've seen all of these in the industry, but it's basically a manual that speaks to how the scheme is going to process the personal information of the members, how it is saved, and how it can be disseminated in certain instances. A PAIA manual, also the Promotion of Access to Information Act. It's actually a pretty short act, but it speaks to if a request is made for information of a juristic entity, it should be provided in a certain format. People can request information in terms of certain templates in terms of that act as well. And then lastly, reporting any personal information breaches to the information regulator. And hopefully this does not happen, but Section 22 is not fun to follow. You would actually need to report this directly to the information regulator. There's a form that you need to complete, and then you need to send through a report to every single individual whose personal information has been impacted by this breach. I'm sure you've picked up on this previously. There's been multiple breaches in South Africa over the last 3 years since the implementation of POPI. The latest one, if you've seen in the news, the Justice Department got a fine for 5 million rand in the last 3 weeks. It's the first fine that the information regulator has actually issued in terms of this, though I think they've received over 500 to 600 complaints. But there's been bank breaches of data, there's been credit bureau breaches of data. It does happen quite regularly. I'm sure you've even received a Section 22 notice at some point in time. So recommended best practices when it comes to this. CCTV is the big one we get on a day-to-day basis. And it's also very important when we're dealing with CCTV is to think about where you as a scheme is going to put up these video cameras that is taking still images or videos of people within the scheme. It obviously can't be unreasonable. It can't face somebody's doorway. It can't face somebody's garden, etc. So it's also a thought process that you need to utilize before you go and actually put this up. But your POPI policy needs to make mention of this. It also needs to make mention of where that information is going to be stored, what information is going to be stored, how long it's going to be stored. And also disclaimer boards within the scheme is very important to notify people that you're actually going to be recording them while on the scheme, whether they be individuals, members, or whether they be visitors or contractors. WhatsApp group disclaimers. I'm sure you all saw this when POPI came out. Everybody on all of their family groups, etc., sent through disclaimers saying, we're not POPI disclaimers saying, the only reason we're doing this is for information purposes. Don't share certain things on the group. You can't disseminate. But I need you to think about your WhatsApp groups within the scheme as well. The reason why I'm saying
I think we might be losing Peter. Just while we're waiting for Peter to reconnect, I think this does sound like a lot and it sounds like a mouthful, but, we're certainly available to help. We have a POPIA toolkit, we have checklists, and we certainly have a very structured and a very simple approach that can be followed to work through this list of expectations. So, nothing to be alarmed about. These are just guidelines of what's involved, what needs to be taken care of. And, it is an important responsibility that personal information is protected. It is a legal requirement. As Peter said, CCTV images are actually personal information of individual people because it can identify them. And therefore, it's very important that that is considered and that's taken into account in terms of the privacy policy for a community scheme. Peter, we lost you there, so I just stepped in, but you're welcome to carry on. Just unmute, Peter.
Thank you very much, Andrew. The last thing that I just want to mention is that make people aware of POPI. If you see information that's being shared across the group, as a trustee, as a director, just send a short message. You don't want to sit in the situation that you need to do a Section 22 application. And that's probably the highest form of responsibility that you sort of need to take when it comes to this. So make sure the manuals are in place and make people aware how the information is being processed. Also with your data contractors, meaning any person that you're providing data to, whether it be your security company, even your managing agency. It's important in terms of their management agreements or in terms of a separate contract to have a data processing agreement in place, which speaks to what information is provided and what information may be utilized and in what circumstances that information may be shared. Thank you, Corinne. You can skip slides for me. Andrew, that brings us to the end of our presentation. I'm just going to run us through the contact details. If you'd like to contact any one of us, please go and do so. We haven't given you our cell phone numbers, but I'm sure if you ask nicely on email, we will do so. Andrew's details, Corinne's details, and of course, my details. You're more than welcome to send us an email after the session, as well as giving us a call on our office lines. And then finally, the one you've probably been waiting for is the Trafalgar governance checklist. If you'd like the governance checklist after the session, please send us an email or request directly in the chat. Siobhan's going to be sending those out on Monday. The session is recorded. It is going to be available on YouTube directly after the session. And then we can provide you with your free governance compliance checklist, which speaks to everything that we've covered today when it comes to the statutory requirements, the legal requirements, as well as certain best practices. We've included the timelines in there for you so that you can go and have a look and be fully compliant and at least ask the questions at the end of the day of, are we compliant and where are we not compliant? If you don't ask the questions and you don't necessarily know, you're not going to know the answers. So ask the questions, run through this checklist yourself, and ask the questions of your trustees, directors, and managing agents. It's important at the end of the day to stay compliant. Compliance is also not just a one-time thing. You can't do POPI once and think that you're 100% compliant. It's going to be a process. It's a annually reviewed process in most instances. But this list is going to take you through everything that you possibly need. And like I mentioned, the session as well as the recording is going to be available on YouTube after the session. Thanks, Corinne. Andrew, do you want to take us through the next upcoming webinars and the closing?
Sure. Okay. Thanks very much, Peter, indeed.
Pleasure.
Just a last comment on that. Personally, I think it's a good time for new trustees and directors elected in AGM to possibly use that checklist and with the managing agent go through it. And, you know, in that way, new trustees and directors, and as a refresher for those that have been there or re-elected again, just to go through to familiarize themselves with the details, with the status, with the registration numbers, to look for gaps, and then to double check that compliance is in place, because it is typically an annual cycle, it's a refresh, and it's a good time to do it. So maybe bear that in mind if you are looking for a particular time to do it. It looks fairly onerous, it's got a lot of line items, etc. But, you know, ask for help, ask your managing agent to, you know, give advice. There are, you know, specialists and people experienced in all of those areas that are ready and willing to help. And, you know, I think once you've got on top of it, it becomes more familiar, more simple, and, you know, it does tend to tick over. So I'm sure it's been quite heavy and intense. That hasn't been the intention, but rather just to raise the topics and the awareness, and then to provide the contact details for support and for any questions or queries which might arise down the line. Just the closing comments, and we can finish a bit earlier tonight. We are busy with piloting 2 new systems, which have got significant productivity and self-service benefits. Those are going well, and we should be completed by the end of the year, and that should inform a major system upgrade for us in the new year. So that's well underway, and some exciting times ahead, and we'll certainly keep everyone fully advised of, you know, a online portal with, you know, full self-service functionality, access to management reports, operational reports, reporting maintenance issues, getting status updates, etc. A lot more automation, a lot more efficiency, a lot more self-service driven, and very much an app format, which I think will be very helpful. We're excited to have launched our Trafalgar monthly newsletter, our first edition in the last week. It's a constellation of property topics, of interesting, relevant property information, covering a spectrum of property areas. We have a We have a sort of subscriber list that has developed over the years that was sent out to that. And if any of you did not receive it, please just drop a note in the Q&A with your email address requesting the newsletter. We can add that to you, and it will be a monthly edition ahead. So just to bring that to your attention, and it will also be available on our website. And then lastly, to close, our topic for our next webinar, which is scheduled for Thursday, the 24th of August, 5 to 6 as usual, will be the all-important topic of financial management. Absolutely crucial topic. There's no question that those schemes with effective financial management, positive cash flow that can maintain maintenance, service delivery, municipal payments, they are the successful ones. They're the ones that run smoothly. Those are the ones where there are the least queries and concerns and issues with owners, meaning that effective financial management is an absolutely overriding priority for all trustees and directors. So we will be covering best practices, recommendations, looking at budgeting, looking at reporting, reviewing the monthly reports. We're going to have a panel approach. We will invite an auditor just to talk through some common queries about audits, what goes into doing an audit for a community scheme, what they look for in the audit file, how to advise trustees or directors that are asked to sign off the audits, what queries they typically see and how those are resolved. So we'll try and make it interactive, Q&A driven in a panel format, and certainly something that should be of interest. So please do join us for that. We will send out the invitations as per normal to our subscriber list. You're very welcome to refer those to any friends or colleagues or people that you know might be interested. They're very welcome to attend. And it's all in the interests of sharing knowledge, cross-skilling, and making sure that we emphasize and prioritize important community scheme management elements. So thank you very much indeed. Please don't hesitate to contact us if we can assist in any way. If there are any questions we didn't get to answering this evening, thank you for your time. Thank you for joining us. And we look forward to convening in a month's time. So good night, everyone. Thank you. And thanks to Peter and Karine for presenting. Bye now.